human ingenuity is important in intellectual property creations, whether it's a patent or a copyright, a trademark, or a design. So that's why you see an entire IP system based on persons, humans, human ingenuity, their innovations, creations, and creativity. Copyright belongs to natural person, not to the machine. So same argument goes for the artificial intelligence also. And similarly, it is the prompt is given by the person, whether it is the textual prompt or a voice prompt. And sometimes iterative prompt is necessary. Despite you become a famous prompt engineer, still you're not getting the choice. If there's no originality, there is no copyright. Simple. And what is the originality? Earlier, it is to be the when you write an article, do a painting or a creative, there is a sweat of brow labor theory was there. It's replaced by skill and judgment. There is a skill and judgment in creating pattern. The way you write an article on artificial intelligence is different from your colleagues. Your hard work, your intelligence, your understanding, your language, your expression, the way you use your language, phrases, vocabulary, and all that. AI can't get the authorship. The person behind it who is creating work should get the authorship and ownership.
Without further ado, I now invite Dr. G.R. Raghavender to give his insights into safeguarding rights in the age of AI.
I would like to thank WishwaTalks for inviting me to share my knowledge, whatever I've gained on this important topic, safeguarding rights in the age of AI, protecting creativity, copyright, and exceptions, copyright exceptions, because I don't like fair use. Fair use is American law. We don't use fair use. None of the international treaties mention the term fair use, the exceptions and limitations. And of course, copyright exceptions in an AI driven world. This is the most hot topic. You must have seen the Department for Promotion of Industry and Internet Trade of the Ministry of Commerce and Industry has come out with Gen AI and Copyright Part 1. And the Part 2 will be soon released. At present, artificial intelligence is a very disruptive technology. And if you remember in 2016, Niti Aayog came with the National Strategy for Artificial Intelligence. It saw the government departments and ministries work collaboratively and cooperatively, not work in silos, because the AI is going to be the backbone of the Industry 4.0 manufacturing, where it has replaced man to machine to machine to machine manufacturing. It will be driven by AI, a lot of data, 3D printing, and 5G, 6G technology. Is this going to change our life? Yeah, it is already changing our life. But it is we should recognize that it is a general purpose assisting tool. It should not replace humans. Just like I remember when World Bank funding came when I was working in the Department for Economic Affairs, World Bank Division. So install computers everywhere in the North Block. Entire staff was scared. No, we are going to lose job. Then I have to tell them, no, you are going to enjoy your job. To save a lot of your labor and whatever you are going to type and create work, you're going to save. Similarly, AI is going to do the same thing. But copyright is the big issue. Is it going to destroy the copyright or it is going to replace the humans? But I don't think it's going to replace the humans. It will be assisting tool. Whenever, the very technology gave birth to copyright. When Johannes Gutenberg invented printing machine and people stopped calligraphy, handwritten books, and it replaced printed books. And 1710, England, Great Britain at the time, the parliament introduced the first copyright law in the world. That is Statute of Anne with 25 years of, the term of copyright. Slowly, term of copyright increased, and 1832 bill was introduced with the concept of post mortem auctoris, that is, life of the author plus 25 years, because the author may die before his book is famous, his painting is famous, his work is famous. So it is the a kind of intellectual property, intangible property. So I know 25 years after his death, the family will sustain their life by getting the incentives. So it is the personality theory. So human ingenuity is important in intellectual property creations, whether it is a patent or a copyright, a trademark, or a design. So that's why you see entire IP laws protect the rights of a person. Entire IP system based on persons, humans, human ingenuity, their innovations, creations, and creativity. So that's why all IP laws are protected persons. Only the person will file a patent application. That is a natural person. That's what the test which Stephen Thaler has done. Stephen Thaler filed an application for granting a patent. An inventor, instead of his name, he mentioned the artificial intelligence robot called Davos. So Kathy Wedel, at the time the head of the U.S. Patent Office, she rejected it. Matter went to Supreme Court. The famous case, Thaler versus Wedel. Supreme Court rejected that. No, the inventor has to be the natural person, not the non-human or a machine. No, even he tried again creating a collage of photos, creating a new photo, and applied for the copyright in the Copyright Office. And my friend Shirap, the registrar of copyright, she rejected it. Again, matter went to the Supreme Court. It is this Thaler versus Perlmutter. This is the case, Supreme Court of America. Again, they said the expressions from the human, natural person. Copyright belongs to natural person, not to the machine. You must be knowing that even animals can't get a copyright. The David Slater, natural, animal photographer, he kept his camera on a tripod in international jungles. A macaque monkey came, which is famously called Naruto. It took its selfies. Monkey selfie it became very famous. I challenge you, you can take better selfie than Naruto, which took that smile, killing smile. And that he commercialized, and PETA opposed it. And PETA lost the case in the first court of instant district court and went to the court of appeals, because both courts said that copyright is given to the person. Even though who gets the copyright, person clicks the camera photo. And their argument is monkey clicked the camera, took selfie, and David Slater has not taken. No, it's wrong. But camera is so even though it is there, it can't be getting. So same argument goes for the artificial intelligence also. Whether person will get IP, that is the copyright, or non-human. If AI is getting a copyright, why can't your camera or mobile should get a copyright? What are you doing at the end? You simply click. Remember the old films, Satyajit Ray films and Gurudutt films, especially that black and white films. The mostly attracted people because of the way the camera, cinematographer, and the director, whether it is Gurudutt or the Satyajit Ray, use the camera, capturing the light in the room or in the building. That is the great thing. Man, the way camera install, camera use, the conditions created, then camera is getting. And how can you give the right to the camera? And similarly, it is the prompt is given by the person, whether it is the textual prompt or a voice prompt. And sometimes iterative prompt is necessary. Despite you become a famous prompt engineer, still you're not getting the choice. It doesn't mean that the entire copyright will go to AI or that a camera, that mobile device or that. So person behind, even though you are creating a choral diagram using a special software, you're creating a design on your laptop or a desktop. So copyright should go to you, not to the software. No, arguments all come whether the company owner, Microsoft, like OpenAI, or the developer, like maybe a Hyderabadi working in the Microsoft creating that special software, the person using it. So finally, the law has to settle. We should not award any copyright to the machine, because entire copyright, international copyright system based on the personality, and it shows the culture. What prompted Copyright Office, Government of India, my own ministry, to give co-authorship that Now they later they announced that we have cancelled. But even cancellation cannot do. They can do only corrections and spelling mistakes, address mistakes. Any cancellation and rectifying from the register, even registrar of copyright has no power. So the powers are with the Delhi High Court. Delhi High Court has to pass an order after hearing the person who got the that incorrect copyright, whatever. So authorship has to be the person generating it. What happens now? Now in the Hollywood and Bollywood, you've seen many films coming, 3D films, and VFX is being used. Earlier, VFX was used. Now, AI generated VFX are coming. You must have seen the Avatar, the latest Avatar Part 3, or our own Indian domestic super hit film, my favorite god, Narsimha Avatar. You guys must have seen that 3D film. Again, AI is used, VFX effects. So who will get copyright that? So what a film community is doing, Hollywood must have read in the newspapers that the entire Hollywood authors, songwriters, editors, scriptwriters went on strike, that they were fearing that the producers, to save money, they may introduce AI and remove them. So their bread and butter will be endangered. So finally, entire industry gave assurance that only AI assisted works will be recognized, but not the AI generated works. So any lyricist, let us say the Guljar or Javed Akhtar writing a song, or any music composer, Lalit Pandit or Salim Suleiman creating a music. So once the work is done, once the script is written, once the dialogue written, once the story is written, they may feed into this AI to fine tune it. So that is the AI assisted work that need to be recognized, where the contribution of human is very substantially high and significant, and making the AI creation only the minimal. Then AI assisted work can be done, recognized. That too when there is a originality in that. Entire copyright survives with the concept of originality. If you copy somewhere, you cut and paste from somewhere, no, there is no copyright in that work. So a copyright infringement, that is the big thing happening. How AI works? AI works, it crawls, it scraps text data, mines all the information, and it does the classification, categorization, creates the data sets. Even tokenization happens. So if you take this very sentence, even tokenization happens. Each it creates tokens. How it creates token? Tokenization itself, one word. It won't write in that English letters. It converts into binary numerals. Whenever numeral comes, the AI will be recognizing. So entire your thing is converted in the numerals, binary numerals there. And then it remembers it that, and it comes out. That is the foundation training happens. Well, AI companies are saying, look, we are not copying it. There is no infringement. Why should you take permission? All authors, right owners, and you have to take for consent to access. And then for reproduction and creating your training, you have to pay royalties to us. They're saying that everything is in the public domain. We have right to go and scroll and scrap. No, the concept of public domain itself a myth. Everything available over internet, you can't call that it is in the public domain. What is in the public domain? It is out of copyright works. In India, life of the author plus 60 years, that is cross Mahatma Gandhi works, Rabindranath Tagore works, all these are public domain. You can take it, translate, because copyright is bundle of rights, economic rights, for reproduction, communication to the public, translation, adaptation, public performance. You have to take the permission of author or a right owner, otherwise infringement of copyright. Or a compulsory license under granted by the commercial code now, that is to be given by the registrar of copyrights to commercialize that work. You have to pay at the end. Even the statutory license system is there, but everywhere there is a payment of royalties fixed, either voluntary negotiated or non-voluntary license are issued. So without that, how you are using for this $1 billion AI industry the entire content created? So that is the big problem. So they always sarcastically say that AI companies are parasites. They survive on the pre-existing content. Content may be a book, a poem, an article, a photo, or a piece of music, or a film, a video, or everything it will crawl and learn. The foundation model is developed on the pre-existing work. It is not thinking and creating like you and me. So if you are commercializing the content, you have to take permission from the right owners. That's what they are not doing. So that is a copyright protected work that is in public domain, which may be illegally uploaded, made available. They are pirated works. Second category. Third category is the publicly made available. What is publicly made available? The various reports and books which universities, government websites have given humongous data, humongous documents, articles, reports are there, public domain, so that public will go and read and know what are the government policies or educational policies, what this university, what kind of work they are doing. Even if access free books available, open access books, open source, they can't go, they may go crawl and scrap. But if they put that opting out from this thing, they can't do that. That's what the EU has introduced. But EU has given exception in a wrong way, which India is not following that method. Giving TDM exceptions to the AA companies is wrong. TDM exception has to be given for the education and research, not for the AA companies, because they're commercializing it. That is important. And whatever AA generate will be homogeneous. Homogeneous means repetition from the existing work. Immediately the moment you see it, somewhere I heard this. It may be a new work. It looks like that. That will be there. Just like identical twins looking same, but yeah, the genes may be different. But here, repetition will be there. Coming to last point, that is originality. No originality. The concept of originality is entire copyright system is wedded to originality. If there's no originality, there is no copyright. Simple. And what is the originality? Earlier, it is to be the when you write an article, do a painting or a creative, there is a sweat of bro labor theory was there. It's replaced by skill and judgment. There is a skill and judgment in creating pattern. The way you write an article on artificial intelligence is different from your colleagues. Your hard work, your intelligence, your understanding, your language, your expression, the way you use your phrases, vocabulary, and all that. AI can't get the authorship. The person behind it who is creating work should get the authorship and ownership. If you see the terms and condition of OpenAI, Microsoft, Copilot, the Gemini, or DeepSeek, or Claude, or Perplexity, everything is the person who is creating is getting. Only is subscribing it to create that AI system, and they are saying that any infringement happening is not our headache, your headache. The person who is using their headache. So you can't give copyright to them. But there is no transformativeness in this, except the copying and transforming and paraphrasing and putting in the new way in AI. Even though you ask prompt and the new thing, but it has to create a 3,000 word article or a fantasy novel or a romantic novel or a tragedy, whatever AI is writing, but that's based on the prompt, based on the already such works available with on which it has been trained. Its foundation model has been trained. So there is no original in that. So that this story. So I'm dead against recognizing AI generated works. Yeah, only human made works should get copyright. AI assisted works with the human involvement, substantial human involvement should get. With this, I conclude my talk. Thank you.
Thank you so much, sir, for your time and for the talk. I'm quickly going to just move on to the questions. How, according to you, can we protect rights of poor and lower socioeconomic status people? And how can we protect their rights in the time of AI and AI generated tools and AI tools?
That is the policy initiative which many countries are considering. The EU has introduced TDM exceptions that the companies, AI companies, have right to crawl and scrap everything unless and until the author or right owner opts out. Many publishers in their books copyright page, they mention that we are opting out from any text data mining or use by AI. But publishers can mention it. But self-publishers and individual authors, individual creators, very difficult. And AI won't recognize these things. Still, it will crawl and scrap it. This is going to be a big problem, implementation problem. That is the reason why The policy should be in such that no, text data mining exceptions should be given to the machine. No, they should go for the voluntary licensing with the other individual authors, societies, or publishers. Why don't you pay to the individual authors, author societies, and publishers? That is what our argument. So the matter is not settled. Different countries are handling in a different way. Let us hopefully there will be international norm setting in this matter soon under the WIPO. Even WIPO also conducting various seminars and workshop conferences, inviting experts to speak on this matter. And the policy is still going on because EU has done by giving wrongly TDM exceptions, which UK wanted to do. Entire parliament opposed. As already told you how thousand performers came out and said that no, it can't create autonomously without using the pre-existing work. And India has also given its first paper on this part. And America is based on the court judgments. There are more than 65 cases are pending. Two judgments have come.
Sir, an author produces literary work using partially the context from the AI. Will the author have copyright on whole of his work or only that part of which that he has created on his own?
That is what the present law, if you see the copyright author for the computer generated is the person behind the work at present law. In the future, it goes author for the AI generator work, who is the author. Again, that there should be originality in that. Computer generator work means I will collect about 50 books and cut and paste in the computer and generate an article. It's a plagiarism. It's an infringement of copyright and also plagiarism. So both happening there. It should not be like that. So when you have written an article or a book, a created artistic work or a painting, or even take your own photograph, you upload and then you're creating a image. So copyright belongs to you. So you can't take somebody's photo and do a Ghibli image and claim a copyright.
There's a question, is it mandatory for an author musician to provide a disclaimer that a particular music work is made substantially using AI? Like this is an AI generated content in apostrophes.
Yeah, of course, it will be an infringement without authorization in creating a work. So if you're creating a AI generated for criticism and review or a satire just for a fun sharing and social media, it's okay. But if you are commercializing it on your YouTube channel where a subscription happens, advertisement revenues are coming, then you will be in trouble. Number one, you have to take permission from the authors and right owners of the music from whom you have whose works you have used in your music creation, even though you may be having your own music. And some tunes and patterns have lifted, some notes have been lifted from other work.